Good morning, everyone. My name is Brad Whittle, and I'm the president of Gallagher Transport, and I'm a board member of the World Trade Center. Gallagher is a licensed customs broker, and we've been helping clients around the world, and especially in the Denver market, with import and export transactions for over 25 years. Now more than ever, trade and tariffs are at the forefront of discussion in today's business. Our team at Gallagher helps companies navigate the ever-changing environment surrounding U.S. customs. We can help your company devise strategies to minimize duties and company risk on goods imported into the United States. Gallagher is a proud sponsor of today's event. We're longtime supporters of the World Trade Center, and we feel it's important to be involved and promote discussions and sponsor events like this that promote trade throughout the world. Please take an opportunity to stop by our booth out on the trade show floor. And now I'd like to introduce our next speaker, David Sanders. Originally from Denver, David is a partner at Cassidy Levi Kent in the Washington, D.C. office. David has over 29 years of experience in customs and international trade matters. David counsels and represents U.S. importers on import regulatory issues handled by U.S. Customs and Border Protection and Homeland Security. David represents clients before U.S. Customs and Border Protection in a wide range of proceedings. Recently, with the implementation of Section 232 and Section 301 measures on imports and the imposition of additional duties, Sanders counsels clients on strategies to minimize duty risks associated with these measures. He also represents clients in litigation before the U.S. Court of International Trade and the U.S. Court of Appeals for Federal Circuit, and assists clients in developing, implementing, and documenting import and export compliance programs adapted to their international business operations. David received his JD right here from the University of Denver, Sturm College of Law, and his BA from the University of Michigan. Please join me in welcoming David.
We live? There we go. Great, thank you, and good to be here. I'm gonna walk around and not stand right up front. I have a number of slides that I've prepared for today. In fact, this morning I was updating them because there's so much new information that's just happening around the clock. And so we're going to talk about that. Certainly the whole China position is one that is tough to swallow for those importers who utilize China as a source. So we're going to talk about these tariffs. There are a few tariffs currently in place, as we all know. In particular, we're going to talk about the regular tariffs that were here before all this new stuff happened, before this administration came in and came on with 232 and 301 and even 201. But the most favored nation duties are those in the normal tariff schedule, typically ranging from free to probably close to 15%. That was before. Now we've got 232, 301, and Section 201. The second point, AD/CVD, anti-dumping and countervailing duties, are still here. These are the result of cases that are brought by domestic industry seeking relief, protection from imports, and typically they involve a particular product from a particular country. All of these areas, really the last four on here, AD/CVD, Section 232, Section 301, and Section 201, all of these are areas where U.S. Customs and Border Protection today is paying a lot of attention. And as a result of some of these programs and imposition of these duties, many companies have made changes to their business in an effort to try to minimize and mitigate the risk. We're going to talk a little bit about that. Most recently, and the announcement was actually published, I believe, in the Federal Register this morning, a new list, a list 4 on Section 301, and these are duties imposed for China's, in retaliation against China's policies, were announced by the White House. These take into consideration another $300 billion of goods, and these are all goods that are bound for the United States. As with the other lists in Section 301, the administration has opened this up for a comment period so that those interested parties could comment as to the impact that these duties may have on their business. The extent to which that's going to be regarded is unknown. So far, we've seen very little activity when it comes to the 301 exclusions. On Section 232, we've seen more progress. So how do we avoid and minimize in this environment of a lot of attention and a lot of emphasis on duties? Well, it depends on the type of duty that we're talking about. When it comes to anti-dump countervail, which are the trade remedies, typically one of the most common ways to approach that is to try and establish that the product that's potentially subject to the order is out of scope. Another way is to vigorously defend that case before the various administrative agencies, the Department of Commerce, the ITC, in defending against the dumping charge. On 301s, which was most recently announced, there is a process of exclusion requests. At the very beginning, the comment period, which I just mentioned for List 4, there's an opportunity to try and establish that the product, the tariff line alone, just shouldn't be there. And that happened earlier on with certain products like smartwatches. As a result of the industry and pressure by the administration, they were able to get them to keep smartwatches out. At one time, smartwatches and routers were covered by the same tariff provision, and they since reduced that. Can everybody hear me, or is this echoing? We're good? Okay. Section 232, again, exclusion requests. When it comes to looking at one's imports, there's a few other methods that we try to apply. And one is to re-examine the tariff classification. Now, sometimes this doesn't work. Sometimes there's no exceptions. There's a clear tariff classification for a product. But in other cases where products are crossing the line and may be classifiable in more than one provision, it's okay to try and explore that and to pursue the tariff classification in the provision that's not subject to any of these duties if that's available. Finally, another approach that importers have used, and they're doing it today and they've been doing it since all of this got started, is to explore ways to transfer production. And sometimes, depending upon the complexity of the product, there may be several processes that it takes to build a product. And sometimes there may be certain parts of that production that can be moved to another location, and that might be sufficient to confer origin. These are very fact-specific types of situations. The doctrine of substantial transformation is what is applied in those situations. And the state of the law of substantial transformation, if you can believe it, is in a state of flux. So here we have a very aggressive administration imposing duties. Then you have a regulatory body that's administering and interpreting these types of things. And the doctrine of substantial transformation appears to be eroding to a certain extent. However, there's hope. Let's talk about 232 in a little more detail. 25% duty on steel products, 10% on aluminum. For certain products like Argentina, Brazil, and South Korea, there are quotas, meaning the 25% doesn't apply until a certain quantity of those products is reached, at which time the duty kicks in. Same goes for aluminum from Argentina. Other countries like Turkey are getting a 50% tariff on steel. The Section 232 tariffs affect most countries in the world, not just China. So what we're seeing is a lot of European companies who export steel and basic primary products, aluminum, that are used to produce product here in the United States are being hit with these 232 duties. Now, there's an exclusion process for 232, and it's alive. It's getting better. The basis for granting exclusion requests are up here on the board. Essentially, To grant an exclusion request, you need to establish that the product is not produced domestically in sufficient and reasonable quantities, quality, and that there's no other national security, or that there's a national security consideration that warrants exclusion. In other words, we need that for purposes of our own defense. Where they filed on regulations.gov, the process is supposed to be changing and it's supposed to get better soon. For those of you who are interested in these slides, I know I'm going through them very fast. If you want a copy of them, please come up to me afterwards, give me your card, and I'll see that you get them. I'll have them emailed to you. There's a lot of detail here, and this is always changing, but in terms of the current statistics, these are up on the board. In terms of exclusion requests filed, there have been about 45, going on 46,000. About 21,500 have been approved, 6,500 denied, and more pending. On the aluminum, you can see the numbers up there. The bottom line is that some of these exclusion requests are being granted. And so if you are an importer who imports some primary forms of steel or aluminum, and when I'm talking forms, it varies from sheet to steel rod, wire rod, all these different products that oftentimes are the result of very sophisticated metallurgy that may go on in other parts of the world, and exclusions are being granted because these things are just not domestically available. If an exclusion is granted for a 232, it's good for a year, and it's good for a year from the date that the filing was made. So if you file it a year ago and the agencies responsible for determining this, and right now it's a BIS, which is part of Commerce, takes them a year to even look at it. Let's say you get the exclusion, that year is going to be good for a year from the date they gave you the exclusion. It's going to date back to the date you originally filed it. So essentially 2 years. So there's some real value to that. If an exclusion is denied, and we've seen this, and oftentimes in these types of situations, I've had clients who have tried to file these on their own and then maybe gotten denied and come and said, what did we do wrong? Can you help? And oftentimes it's a matter of a tariff classification error. The only way you can resubmit an existing exclusion request is if you keep everything in your application the same, but you update and change the tariff classification. If you have to change more contents of your application, then it goes to the end of the line and the submit date is the effective date. So we've seen a lot of this, and there's been a lot of confusion. A lot of importers who have done this on their own may not have been using proper classification to begin with, and Customs and Department of Commerce notifies them of that, and then they have to go back and refile. In terms of objections, the way the process is set up, importer files an exclusion request. Objections can be filed by interested parties. Who's an interested party? For the most part, it's domestic manufacturers who claim they can supply the particular product at the quantity and quality that's desired. And the fact of the matter is, when we look at all the statistics, for the most part, whenever there's an objection to an exclusion request filed, typically only 1% of those get approved. Most are denied. I'm sorry, the one other thing I was going to add is that some of the objections that are filed by the domestic industry, if you add all of them up, the amount of product that they claim they can produce well exceeds the capacity, the current domestic capacity. Thus, it's very clear that they're overstating their abilities and capacities. And finally, I think the Department of Commerce and those who are responsible for looking at this are aware of that. So let's turn our attention a little bit to China, which is the big topic lately. Number of different duties imposed on this list. I list them all. There's an investigation launched in August of 2017. In June of 2018, the first list was imposed and 25% duties on that. Shortly thereafter, 25% duties imposed on list 2, which was a very short list. And then very recently, list 3 got announced, which has over 6,000 products. Remember, as there was a positive momentum in terms of getting some kind of progress on a negotiation with China, the president held back lifting the rate to 25%, and then only this past week, when it became clear that the negotiations weren't going very far, he went ahead and said, let's kick it up to 25%. And so that's where we are today with List 3. And then there was List 4 published, which I mentioned earlier on that slide. And that remains to be seen. Just a little artwork here to express what's going on. As far as the exclusion request process for 301 is much less robust than it is for Section 232. The process for List 3, there's been a debate about whether or not there'll ever be an exclusion process for List 3. And at first, it was thought that there wouldn't be. Now, as a result of some pressure by Congress, the statement out of the administration and the Office of the United States Trade Representative is that there, in fact, will be a process. How robust that process is and how effective it will be is another question. Requests have to be product-specific, comprehensive, tariff number has to be correct, and the criteria are not that stringent, although there is an unknown, and that is what effect will granting of this exclusion have on the overall impact of the policy that the administration has. So that's a very broad-based criteria that they can apply subjectively. So unless there's a real need, unless you can show real economic harm, it's very unlikely to get some kind of exclusion. Now we're seeing retaliatory tariffs, and hopefully that will exert political pressure on the whole system to try and come to some type of agreement. I want to talk a little bit about tariff classification and tariff engineering without going into all the details of the slides. One of the things I talked about up front was, in some cases, a product can be modified to change its tariff classification. There's a court case involving the Ford Transit, and recently Ford, that manufactures these trucks in Turkey, redesigned it to put in a temporary row of second row seats. They redesigned it in a way that those seats met all the safety standards, and what they were trying to do is import that product into the United States as a passenger vehicle with a duty rate of 2.5% and avoid a 25% tariff on trucks and cargo vehicles, which is still in place, and it was a result of previous trade wars that went on way back in the 60s. The chicken wars, as a matter of fact. So what Ford did was they designed this truck, they put the second row seats in, they brought them into the United States, and before they delivered them, but right after importation, they removed the second row seats and sold them as cargo vans, and Customs said, wait a sec, you can't do that. You're trying to avoid the duty. You're masquerading this as a passenger van. It's really a cargo van. The importer, Ford, challenged it and said, no, this is an example of tariff engineering, that this is legitimate and there's support for it. And the Court of International Trade, which has jurisdiction over these things, ruled that in fact Ford was right, that the way a product is imported, or the condition of the product as imported, is how it should be classified. So that if you had a vehicle that had passenger seats in it, and the passenger seats met all the safety standards, so it was a legitimate passenger vehicle, it could be imported. And it could get the 2.5% rate. Well, needless to say, as things happen in this legal world, once you get a decision out of one court, if the other side doesn't like it and they're not happy with it, they challenge it in the appellate court, and that's where this is right now. There was an oral argument on this in March, and we'll see what happens. But it was a very interesting argument that I happened to attend because I live in D.C. And it was the panel was very prepared, and they really focused. I'm going to buzz through a couple more things. I want to talk about one last thing about substantial transformation. I mentioned it before. What is it? It's a change in name, character, or use as a result of processing somewhere else. And oftentimes, Customs looks at this to determine origin. There's a great deal of law being made in this area as well, both at the agency level as well as in the courts. and it's going to be tested more. Recently, Customs has gotten very aggressive in finding no substantial transformation in cases where traditionally you would see it. So this is an area that, again, is emerging. It's become more prominent because of the atmosphere that we're in. This is a court case, Energizer, and that's one of the latest court cases on the subject. We expect that there will be more as we progress. I see that I'm out of time, but are there any questions? Who raised their hand? You want to know what happened where? In this case right here, in the Energizer case, it involved a military flashlight. There were about 8 components that were imported into the United States. The flashlight was assembled in Vermont. The claim was for US origin. The court said no, not US origin. The origin of that product is the origin of the components because they were kitted, they came in, the assembly was not that substantial or complex. Had there been a more complex assembly operation, very likely they would have found origin, but in this case they did not. And the problem with that is this is a precedent, and so when the administrative agencies get decisions like this and they want to take a hard line, they look at Energizer because there's language in there that basically says, well, if you bring parts in intending them to be used for something else, then really it's not a substantial transformation. And that's a real problem. And that's really a matter of interpretation by the agency, not necessarily the court. So I expect we'll see more of this. And certainly importers are very concerned about where this is going to go. And Customs is aware. Problem is sometimes you get parts of Customs that are issuing rulings that the other side doesn't know about, and then they have to correct them. And so that's one of the situations that's going on now. More questions? Last question. I'm sorry to go over, there's just so much. And
after a year?
So the question relates to Section 232 and the fact that the exclusion is only valid for a year. Is there a process to reapply? And the answer to that is you have to reapply. So if you have an exception and it's good for a year, you need to refile. It shouldn't be a heavy lift for the agency if you already have an exception, but you're basically going to renew it. So bottom line here, people, if you have steel or aluminum products that are being imported in the United States, whether they're primary forms, intermediate forms, and you're going to further process them, and you cannot source your intermediate or prime material in the United States, then you need to file for an exclusion because they are being given. And we're going to hear an announcement shortly from the Department of Commerce where they are substantially improving their process for doing this. I don't know, has anybody in the room filed a 232 exclusion? Hands? This one in the front. Very few. Bottom line is that process is going to improve and it's going to be effective.